Welcome back. Patrick Kelleher, your elder law care attorney at elderlawcare.com. And this is part 3 of our 3-part educational webinar, how to avoid the 4-headed monster of estate planning and elder law. In part 1, we took you through how to avoid probate court, 2 types of probate court, death probate court, and disability probate. Also, we talked about, in part 2, the estate death tax here in Massachusetts. The threshold is $1 million, so anyone with more than $1 million is going to be possibly obligated to pay estate death tax to the Commonwealth unless they have permissible deductions to get them under that $1 million threshold, or unless they do another strategy we talked about in part 2 is doing permissible estate tax planning, estate tax specific planning for married couples in a revocable asset protection trust, or some people refer to as a revocable living trust. Also in part 2, we talked about how to avoid the 3rd-headed monster, financial creditors and predators, Betty the Barmaids, Bo the Tennis Pro, the Casserole Brigade, and so on and so on. How to protect what you worked hard for from the financial creditors and predators, the times of turmoil that may creep up in your life, your spouse's life, or your children's lives. There's certain asset protection language that is permissible to put in a trust-centered plan to properly protect you there. Now, folks, part 3, we're going to talk about long-term care, nursing homes, Medicaid, Medicare, the cost of long-term care as folks age in place. They say statistically there's about 10,000 people turning 65 years of age every day in the country. And we're going to look at some staggering statistics where the cost of long-term care here in the Commonwealth on average is more than $12,000 per month private paying for a nursing home. We'd have many clients. We've had many clients paying in excess of $15,000 per month for private pay nursing home care. So we're going to talk about that because the average stay in the nursing home, folks, is about 3 years. So when you run the numbers, $15,000 per month over a 3-year period, how much is that? Do the math. $15,000 per month over 3 years, or $15,000 per month over 36 months would be the mathematical calculation on your calculator, or if you're good in math, you write it out on your scratch paper. That is correct. $540,000. That's a staggering number. That typically, from my experience, amasses what someone accumulated in their entire lifetime or lifetimes for a married couple, whether it be their equity in their home or their retirement savings. And it can all be gone in a matter of 18 months, as we'll learn here in an example that I'll be showing you shortly in part 3 of the 4-headed monster. All right, folks, so without further ado, let's get started. I want you to pull up your chair, get your pen and paper out, and get ready to learn, because you're going to learn a lot. You're going to learn about what you can do and strategies that you can undertake now and take action with a qualified estate planning or elder law attorney. And so we're going to teach you how it's done currently under current law with some current fact examples with our fictitious clients in this example, Bill and Mary, and you're going to learn a lot. The key is, of course, folks, is take action. They say knowledge is power, but knowledge is truly not power unless you're taking action and doing something with the information that you learn. So you have a big opportunity here to change the course of your life. And not everyone does it because they sit back, they don't learn, and nobody takes that personal responsibility. And those type of cases usually result in the backside of the cloud, where planning is not done sufficiently or adequately for the family. Their assets end up in the probate court, and the spouse shows up with the ugly milk crate at the attorney's office, or the children show up after the surviving parent passes away, and now you're going through probate court. If you have a taxable estate, you're getting bit by the estate tax monster. And if there's any times of turmoil, lawsuits, divorces, automobile accidents, bankruptcies, times of turmoil, 3rd-headed monster is taking a bite out of the estate as well. Now we're going to be talking about the 4th-headed monster, because the cost of long-term care can be staggering as folks age in place. It's truly an epidemic. So let's get started, folks. All right, so let's take a look at our whiteboard here, part 3, four-headed monster. We're going to talk about specifically Medicaid long-term care pre-planning, okay? Medicaid long-term care pre-planning. And folks, from my experience, pre-planning is where it's at, okay? You want to take action when you're alive and well and do some pre-planning with your qualified elder law attorney. Because from my experience, it will be a smaller investment for you to do pre-planning, and you'll have the opportunity to save a greater amount of assets when you do pre-planning, okay? There's a look-back period now, folks, here in the Commonwealth. It is 5 years. So this pre-planning has to be done 5 years in advance of ever filling out a Mass Health or Medicaid application. I'm going to repeat that. The 5-year look-back period means that you have to get that 5-year clock running. You have to do this type of pre-Medicaid planning 5 years in advance when you're alive and well. Stay undisabled, stay unincapacitated, do that future walk, eat your fruits and vegetables, take the dog for a walk, and take care of your flower garden or whatever your hobbies may be. Stay healthy, stay unincapacitated for at least 5 years. Get that 5-year clock started. And then if the shoe drops after the 5-year period, then you have opportunities to get qualified possibly for Medicaid benefits and have Medicaid pay for your long-term care if you qualify permissibly. And you also have the opportunity to do the 3 Ps like I talk about in the book. You can protect, preserve, and pass down the family assets as a legacy to your why. Your why, folks, should be your loved ones. Could be your spouse, could be your children, could be your grandchildren. Take a look around the room at the photos. Take a look at your phone on your family photos. That's your legacy, folks, okay? So you have a great opportunity here. Let's learn more. So Medicaid long-term care pre-planning, we're going to learn about that. And then, folks, we're also going to learn about Medicaid crisis planning. Crisis planning, although it's not ideal, there's still currently a couple of tools in the toolbox here in our crisis planning toolbox in the Commonwealth. They're not ideal, and from my experience, the situation is not ideal for the client because oftentimes it's going to cost more in legal fees when you're doing crisis planning, and the opportunity to save assets is typically less as well. So you'll see that when we run through the example with Bill and Mary. So let's get started, folks. Long-term care concerns, okay? I mentioned some of this statistical data a few moments ago, but it's worth mentioning again, okay? Statistical data, 70% of people 70 and over will need some level of long-term care someday. 70% of people 70 and over will need some level of long-term care someday. It happened to my dear dad, and then my dear mom almost ended up, or could have ended up in a nursing home if she elected to have brain surgery to remove the tumor that was diagnosed just a couple of years ago. My mom was courageous. She made a brave decision. She went home on hospice instead. My dad, however, wasn't so lucky. My dad took a bad fall at home when he was aging in place, and he split his head open. He was bleeding profusely on the floor in the family home. My mom had no choice but to call 911. My dad was transported to the hospital where they stabilized him, sent him off for rehab. When he wasn't getting better in rehab any longer, the slippery slope of life, he ended up in the nursing home unit at the nursing home, unprotected, because my dad was the gentleman who thought he would never end up in a nursing home someday. But the statistical data is very, very strong, and unfortunately, it came back to bite us because 70% of people 70 and over will need some level of long-term care, whether it's assisted living care or more advanced medical care, such as a nursing home level care like my dad needed. Also, folks, 35% of folks will require nursing home care someday. I sat in on a course recently, a Medicaid specific course here in Massachusetts, and that's the statistical data they shared with us during that course. 35% of folks will require nursing home care someday. That's a big, big number. 75% of single people will lose their life savings within 1 year of entering a nursing home. I'm going to repeat that, folks. 75% of single people will lose their lifetime savings within 1 year of entering a nursing home. Okay? Also received this information, this statistical data from that Medicaid course I sat in on recently. Another statistic here for the married couples. 50% of couples will also lose their life savings within 1 year of entering into a nursing home. Okay? That's for married couples. The private pay rate here in Massachusetts, we typically see is about $15,000 per month private pay for a private room. $15,000 per month for a private room. Average stay in a nursing home here in Massachusetts, we mentioned a moment ago, is 3 years. And again, when you run the numbers, 3 years or 36 months times $15,000 per month private pay for a private room in a nursing home is how much, folks? $540,000. That's for one individual, okay? Show of hands. How many folks have $540,000 in your front pocket? Most of our folks do not, and most people do not. However, most people have a lot of equity in their home, and sometimes their equity will be at risk of being taken. And if you desire to pass your family home down to your children or grandchildren someday, you need to take action and create permissible, proper planning when you're alive and well. Otherwise, you're putting in all that risk. If you have lifetime savings of retirement, 401ks, 403bs, IRAs, and if you don't take action and look at ways of effectively protecting those assets, you're putting them at risk, okay? So let's turn the page here, folks, and learn some solutions, okay? What can you do? What can you do? Medicaid pre-planning strategies, okay? Goal, when you're doing Medicaid pre-planning, the goal is to protect your assets when you're alive and well. Talked about that a few moments ago. There's a 5-year look-back period. You have to protect those assets when you're alive and well. Get that 5-year clock running, okay? And what I mean by that, folks, is here comes our Medicaid Asset Protection Trust, or for veterans, we call it a Veterans Asset Protection Trust, okay? Medicaid Asset Protection Trust, you have to create that when you're alive and well. That's step one of the process, of our 3-step process. Step 2, folks, is getting everything into your treasure chest. Think of your trust like a treasure chest. The 5-year clock does not begin to run until the property is properly put into your trust, or what I like to call your treasure chest. Get your pot of gold in there, or your family home, or the equity in the family home, and get that 5-year clock running when you're alive and well. Medicaid Asset Protection Trust, Veterans Asset Protection Trust. We just talked about how to do that. And again, what is the appropriate age? A lot of folks say, hey, Patrick, what age should I get our home into our Medicaid Asset Protection Trust? Typically, from my experience, my recommendation is usually about 65 years of age would be a good time to get that 5-year clock running. Some folks, from my experience, would like to get that clock running sooner in time because they have a concern or they have a health issue that they're also concerned about. So again, it's a counseling issue. Discuss that and receive advice from your qualified elder law attorney who can guide you what age may be appropriate for you. But what I can tell you, folks that come to us when they're in their mid to late 70s, they're typically getting very concerned or gravely concerned because they know they have to beat that 5-year look back period. Their health has begun to decline. They've had sometimes a series of health issues, hospitalizations, surgeries, and things of that nature, and they're really not confident in some cases whether they can beat that 5-year look back period when they wait too late in the 4th quarter. As I always say to folks, don't wait to the 2-minute warning. Don't wait to the 2-minute warning because you're really taking tremendous risk and you might not be able to achieve your dream snapshot, being up on the front side of your cloud looking down at your loved one someday. And if you truly want them to be singing your praise, you want to take action when you're alive and well. Don't wait too long. So congratulate yourself for taking action and taking this course and learning, being a good student of estate planning and elder law, being a warrior for your family, and not sitting on the sidelines, but learning this information, taking action, and doing something about it, okay? So I applaud you for that. Also, life estate. A life estate is another way to get that 5-year clock running. A life estate, however, not particularly fond of it in some regards because there's drawbacks to it. And that's typically when a person deeds the property to, say, their children, and they reserve a legal term called a life estate, saying you can live there the rest of your life, okay? That still has a 5-year look back period because you're transferring your asset, okay? You're transferring, and it's going to start a 5-year look back period. My concern with the life estate, which can work in certain circumstances, but my concern with that is if the elderly parent transfers their property to their child. Now, their child has an interest, a legal interest in their property, okay? And if the child's going through times of turmoil, say a divorce or an automobile accident, they have an interest in that property. So potentially financial creditors and predators could take a look at that and create some problems for that for the family. Also, my concern is tax reasons. When the children are what they call the future remaindermen or remainder persons on that deed, in that life estate deed, and if mom and dad's health is declining and mom and dad are going to sell that property when they're still living, mom and dad are living there, so they're going to get their capital gains tax step up in basis under section 121 of the Internal Revenue Code. But the children who do not live there, and if it's not the children's principal or primary residence, they're going to have to sign off on that deed. And the children, the future remainder persons or remaindermen, are going to get hit with capital gains tax, presumably on the sale of that property. So that's not always ideal. Also, from my experience, later in life, when the parent is declining in health, and if the family's trying to sell that property, the parent, who's now has diminished capacity, may not be able to sign off on that deed. So that's always a concern as well. So life estate doesn't have all the magic wand remedies that you would like to think it does. It can work sometimes, but again, work with a qualified elder law attorney who can guide you which might be the best strategy for you. And I just explained to you and presented to you some of the possible risk of a life estate. Also, folks, we're going to talk a little bit about the case law here. In Massachusetts, there was some recent case law, the Daly case, the Nadeau case, the Hine case of 2016. And these were big milestone cases here in the Commonwealth where as estate planning and elder law attorneys, what we learned was what type of language is permissible that we can put into our Medicaid trust, our irrevocable Medicaid trust. Also, what type of language we should not be putting in there. That type of language will put you on the radar for Mass Health Medicaid because they don't like that type of language. Long and short of it, you can't have too much retained power or control over that Medicaid trust. You have to relinquish power, and hence the reason why a lot of our clients will pick a trusted adult child as their trustee manager who will manage their Medicaid trust for them as they get that 5-year clock running, okay? An example here, Bill and Mary. Bill and Mary want to protect their house from the nursing home, from the cost of long-term care, from that $15,000 per month, from that $540,000 possibly over a 3-year stretch, okay? Because statistical stay in the nursing home is about 3 years at $15,000 per month. So here we are, Bill and Mary, they have a lot of equity in their home, and under current Medicaid laws here in Massachusetts, an individual or couple for this matter can have a family home, and a family home is considered a non-countable asset up to $893, your principal home, not vacation property, not rental property, not second or third homes. Only exemption is your principal property, okay? Up to $893,000 in equity is considered a non-countable asset, non-countable. It is a non-countable asset for eligibility purposes. If Bill becomes completely incapacitated and he needs to enter a nursing home, yes, if they're house rich, cash not so rich, maybe they can qualify for Medicaid benefits. Their house is a non-countable asset. That doesn't mean it can't be liened later. That means they're house rich, cash not so rich. Bill may be able to get on Medicaid benefits, and Medicaid will pay for his nursing home care as he ages in place in a nursing home. But what happens when Bill dies? What's Medicaid eligible or permitted to do? If it has paid in several $100,000 into Bill's care, then Bill checks out 3 years into a nursing home. What is Medicaid permitted to do? That is correct. They're permitted to lien the home in what they call estate recovery, to be reimbursed dollar for dollar for what they paid into Bill's care during his nursing home care while he was receiving Medicaid benefits, okay? Just want to make sure that's crystal clear. It's a non-countable asset. Doesn't mean they can't ever grab it. It means it's non-countable for eligibility for application purposes. But after Bill dies, they can go back and lien that home. Can they push Mary out of the home? I get that question a lot. Absolutely not. Mary's a community spouse. She can live in that home for the rest of her life. However, if Mary goes to sell the house because now it's a big home, the carrying cost is too much for her, the memories are too lonely and sad for her, and she wants to move closer to her children, which is not an uncommon scenario, and she wants to sell that house, guess what? She's got that big fat lien on there that she's going to have to pay the Medicaid when she's selling that home, okay? Also, when Mary checks out years later, then the children are going to have to pay that lien. Likely the kids will be the beneficiaries, and the kids would have to pay that lien. So that's if Bill and Mary don't take any action. But let's talk about if they do take action here. If Bill and Mary want to protect the equity in their home, they say, hey, Patrick, we want to create a Medicaid asset protection trust, or if Bill and Mary are veterans, we create a hybrid called a Veterans Asset Protection Trust as well, to entitle or give them the opportunity to apply for veterans benefits, maybe veterans pension benefits called aid in attendance benefits, a little known VA benefit. Again, the standards are you have to be indigent, you have to be impoverished to qualify for those benefits, just like you have to be indigent and impoverished to qualify for Medicaid benefits. But again, it's a nice sweater in the suitcase, especially for veterans. And they ought to know that that's a planning strategy that you can undertake with your state elder law attorney. So Bill and Mary, step one in the process here, folks. Let's talk about step one. Step one in the process, they create their Medicaid Asset Protection Trust, Veterans Asset Protection Trust, let's say October 2020. And they create their Medicaid Asset Protection Trust, Veterans Asset Protection Trust in October 2020, and that is step one in the process. Is their house protected today? Not at all, because it's step two of the process, and that's called trust funding. We've learned about that a little bit already in our program here, and this is our proven three-step process, and I like this chart right here because it shows a proven three-step process. Step one, you create your trust. Step two is called trust funding. It's a legal process of retitling your assets into your trust. So what does Bill and Mary have to do? They have to get their house deeded into their Medicaid Asset Protection Trust. That's correct. Get the house and the equity titled into the Family Medicaid Trust, because folks, that's where the magic happens. That's where the 5-year clock begins to run on that 5-year look back period, okay? So Bill and Mary do the future walk, and they started the clock and say October 2020, and they get way out there and say October 2023. Is the house protected 3 years later? Because it's a 5-year Medicaid look back period, meaning that you have to be alive and well, unincapacitated, non-disabled, undisabled, and not needing Medicaid benefits for a 5-year period. So say we get out there, let's go into November 2025, say 5 years in a month. And then the shoe drops for Bill. Bill's alive, but he's alive not so well. What's the situation now? Is the house protected? The answer is yes, under current Medicaid laws, because Bill and Mary took action when they were alive and well. They did that 5-year, what I call future walk. They stayed alive and well, unincapacitated for a 5-year period, and beyond 5 years and a month, just to be super safe. If the shoe drops for Bill, he's unincapacitated, like my or incapacitated, I should say, completely incapacitated, like my dear dad was back when he entered the nursing home, and he was considered a fall risk and not able to stay at home any longer. It was dangerous for him and my mom. My dad entered the nursing home at that point in his life. So in this situation here, the big win for Bill and Mary, if Bill is incapacitated, completely incapacitated, can't be cared for at home any longer, he could look to get on Medicaid benefits, have Medicaid pay for long-term care, and the great news, the family home up to $893,000 is protected. Protected for whom? Protected for spouse Mary and their 3 children, Mo, Larry, and Curly. So Mary gets the house, then their 3 loved ones, Mo, Larry, and Curly. And that's how it works, folks. That is pre-planning. Really, really important. The biggest takeaway is get that 5-year clock running when you're alive and well, and work with a qualified estate planning and or elder law attorney to help you navigate through this and get this clock started for you and your family. Don't sit on the sidelines. Don't wait for someone to do it for you. Get off the sidelines, get on the field, and take action. Take that personal responsibility and get that 5-year clock running and pre-planning. Okay? Other pre-planning strategies, folks, we talked about the Medicaid Asset Protection Trust. We talked about the Veterans Asset Protection Trust. We know there's a 5-year look-back period on Medicaid benefits. Currently, there's a 3-year look-back period for VA benefits. A couple of years ago, there was no look-back period on VA benefits. But October 2018, the VA imposed a new law requiring a 3-year look-back period for folks applying for VA benefits, okay? Medicaid will is another planning strategy right here with a testamentary trust. We would typically create a Medicaid will or Medicaid testamentary trust type of will with a Medicaid asset protection trust for a married couple. And why would you want to do that? Because say Bill and Mary are aging in place, Bill becomes incapacitated, and Mary's the community spouse living in the community. And you do all this advanced planning, comprehensive planning to protect the family assets, and everyone's focused on Bill because he's in the nursing home. He's what they refer to as the institutional spouse. But what if something happens to Mary? That happens sometimes because a caregiver is a very stressful job. Mary living in the community, and she checks out unexpectedly. You better have a Medicaid will with a testamentary trust because you don't want all the assets that Mary owns in the community going to her husband Bill in the nursing home receiving Medicaid benefits. How come? Think about it. Because number one, that's going to put Bill over asset and disqualify him from his Medicaid benefits. Bill has to be impoverished. He has to be indigent. He can't have more than $2,000 in his name in a bank account. Now, if Mary checks out in the community, Bill likely, if you don't have the proper planning in place, is going to inherit everything. And he's going to be an unintended beneficiary at that point. And that can happen. You don't want that to happen because that's going to put him over asset, knock him off his benefits. He'll have to reapply, and it could put some of those assets, if not all of them, at risk. So you don't want to do that. Solution there, folks, is what they call a Medicaid will, a testamentary trust, and you want to do that as belt and suspenders type of protection when you're working with a married couple and they're doing Medicaid crisis planning. So make sure the will, the companion will, we'll call it, has testamentary trust Medicaid powers in there for the community spouse. Okay, really important. We already talked about a life estate deed, and it may work, but there's also some downsides to that with giving up control. If the children are on the deed now and they go through a lawsuit, times of turmoil, automobile accident, divorce, separation, bankruptcy, poor decisions, their name's on that deed. And they can get called into play there in a litigation type matter. Also, if you go to sell the property in your lifetime, you're the parent, your children are on the deed, they're going to need to sell that deed or sign that deed and sell that property with you. When the kids aren't living in the home, they're not going to get that Section 121 capital gains tax exemption, which is $250,000 per person, but that person has to be living in the home. So the children typically aren't living there. They have their own homes, their own families, and now the kids are going to have to sign that deed, and they're going to get a big capital gains tax bill and they're not going to be happy. So you really need to know that, and talk to your CPA, tax attorney on any tax matters, okay? This is not tax advice, this is just education, information, and you really need to talk to your tax professional before you're doing any of this type of planning. Also, another reason I'm concerned with a life estate deed is oftentimes folks create these type of deeds when they're aging in place, usually fourth quarter of life. Now, if they completely decline and the family needs to sell the property because mom and dad aren't doing well any longer, mom and dad are going to need to sign off on that deed along with the children. If mom and dad do not have the requisite capacity and competency, if they have diminished capacity, they may not be able to sign off on that deed at that point in time. Now the family has to go off to probate court for a conservatorship to get authority to sign that deed. So there's some of these shortcomings or downsides from my experience with life estate deeds. They can work in certain circumstances. Again, work with your qualified estate elder law attorney. What about this, folks? Long-term care insurance. Show of hands, how many folks have long-term care insurance? Out of all the folks that I've worked with, only about 5% from my experience of our clients have long-term care insurance policies. If you can afford one, by all means, you should invest in a long-term care policy. Best time to get a long-term care policy is probably usually in your 50s, sometimes 60s, when you're in good health, because the premium, just like life insurance, typically will be less, and you'll have better opportunity to qualify for those type of benefits during the underwriting period, or process, I should say. From my experience, when my clients are in their 70s, they've had multiple surgeries, multiple health issues, and now they're applying and considering long-term care insurance, they typically don't qualify because of their health issues and because of their age. And if one of the spouses do qualify, the premiums can be very expensive. I've heard quotes in excess of $10,000 per year for that long-term care policy. But it's important. It's an important pre-planning strategy. And from my experience, it's a nice belt and suspenders type of protection to have as you're aging in place, okay? Really important. So I would suggest work with your qualified insurance professional, work with your qualified financial advisor, and consider and look into and do your homework on long-term care insurance.